The first time I saw the notice stapled to my boathouse, I thought it was a prank. Effective immediately, the dock behind Lot 17 is to be considered shared community property, per HOA Ordinance 4.3b. Signed, HOA President Elaina Fairgrove. My name is Preston Langley. I've lived on this lakefront property for over 15 years. Built the dock with my own hands and permits. Paid the fees, filed the paperwork. There's a weathered photo in my garage of me and my son, Brandon, holding the first plank before we bolted it in. So when Elaina, our bleach blonde, sun hat wearing, HOA tyrant decided to declare my private dock community property, I knew something shady was going on. I took the notice off the boathouse and marched up the hill to the community center, where the HOA board was mid-meeting. Elaina sat at the head of the table in a leopard print blouse, sipping from a stainless steel water bottle like she was presiding over the Senate. "Elaina," I said, holding up the notice, "you want to explain this." She didn't even blink. "Preston, that dock extends over the waterline, which is technically community space. Our new ordinance reflects that. Waterline or not, it's on my deeded property. You've seen the survey lines." She folded her hands. "We're updating the bylaws. Everyone deserves equal access to the lake." "Equal access to my dock?" I asked, raising an eyebrow. She gave this little laugh like I was being unreasonable. "You're not being very neighborly about this." Neither were the two guys on the board who suddenly found themselves agreeing with her, even though one of them, Greg, had asked to borrow my ladder last month and still hadn't returned it. I didn't argue further. I just walked out. That night, I checked my property deed again, the one filed with the county when I bought the place. It clearly showed the dock every inch within my lot, no shared easement, no gray area. I also pulled the permits from the city's website, all legit. I printed everything. The next morning, I came down to find two teenagers I didn't know sitting on my dock, fishing. One of them had a full tackle box spilled out. The other had a giant Bluetooth speaker blaring country pop. I kept it civil. "Hey fellas, this is private property." "HOA says it's community now," one of them replied without looking up. I walked back to the house and called my attorney. "Hal's a guy I went to college with. Doesn't like HOAs any more than I do. Send me everything," he said. "Let's shut this down." By the weekend, Elaina had posted a laminated sign at the entrance to the dock that read, "Welcome to Lakeside HOA Shared Dock, Respect Our Space." That's when I installed the trail cam, just above the boathouse door, motion activated. By Monday, I had footage of Elaina strolling down the dock, pointing at things with some clipboard-toting stranger. That same day, I got a letter, a fine, $500 for obstruction of community access. I laughed out loud, then I got to work. By Tuesday, Hal had reviewed everything I sent him and called with a tone I hadn't heard from him since grad school, focused, sharp, and a little amused. "They're bluffing, but this isn't just overreach," he said. "They altered their bylaws without a proper vote." "That's a violation right there." I leaned against the kitchen counter while my coffee went cold. "That clipboard woman on the dock, any idea? Possibly a surveyor, or someone they're trying to convince it's theirs. Either way, get her name." I already had the trail cam footage queued up. That night, I zoomed in, frame by frame, until I caught her ID badge swinging on a lanyard. County Real Estate Development Office. Name, Dana Strickland. Before I could even process why the HOA would bring a county official onto my dock, I found out. A notice came in the mail the next morning from the zoning board. "Preliminary review of parcel for community easement pending." That's when it clicked. They weren't just trying to let people fish off my dock for fun. They were trying to reclassify part of my land so the HOA could claim control over the shoreline. I drove straight to the county office and requested a meeting with Dana. She met me around noon, polite but wary. "I'm not here to argue," I said, laying out the printed site plans and permits on her desk. "But you need to know the HOA doesn't own this dock. They didn't build it, fund it, or maintain it, and they never had permission to petition for easement over it." Dana scanned the papers, then sat back. "They said it was a shoreline compliance issue. that the dock extended into common use water and had been flagged by multiple homeowners. I looked her in the eye. Did they mention I've had this dock for over a decade, and that it was approved by the city before half the homes around here were even built? She blinked twice. No, they did not. I thanked her and left, but not before requesting a hold on the easement review pending a formal challenge. She agreed. Back home, I noticed something strange. Someone had rolled my kayak onto the grass and left the hatch open. It hadn't rained, no wind. I checked the footage again. Around 3 that afternoon, HOA Vice President Todd ambled down the dock, looked around, and started pointing at the base of the boathouse like he was inspecting it. Then he walked off without touching anything else. Next day, I received another fine, this one for unsafe storage of recreational equipment. That was the final straw. I filed a formal complaint with the city's HOA Oversight Committee. Most residents didn't know that even private HOAs have to adhere to municipal standards when altering covenants or enforcing rules. Hal helped me draft the complaint, complete with timelines, footage, permit copies, and a statement of intent to pursue legal action if the HOA didn't rescind its fraudulent ordinances. Elaina called a special emergency meeting that Friday. I showed up early, sat right in the front row. The community center buzzed with whispers. Word had started to spread. Apparently, I wasn't the only one getting hit with selectively enforced fines. A retired vet named Carl had been cited for improper flag placement on his porch. A nurse down the street was fined for excessive driveway usage, whatever that meant. Once Elaina stepped up to the mic, she launched into her usual speech about upholding neighborhood standards. I let her talk, nodding politely. Then she got to the part about enhancing communal lake access, and I stood up. Elaina, has the HOA voted on the new ordinance? She froze. The board has the authority to. No, I interrupted, you don't. Not without a vote by 2/3 of the homeowners, as required by Article 7 of our charter. You didn't notify us. You didn't file minutes. And you submitted a fraudulent easement request on private property. The murmuring in the room turned into full-on chattering. I've filed a formal complaint with the city, I continued. And if you don't retract the ordinance by Monday, I'll file suit for property interference, fraud, and harassment. Todd stood up. You can't threaten us. You already trespassed, I shot back. I have you on camera inspecting my boathouse without notice or consent. Elaina tried to regain control. We're simply trying to maintain harmony in the neighborhood. I pulled out a folder and handed it to the nearest homeowner. Here's a copy of my deed, permits, and the complaint filed with the city. Pass it around. She hissed something under her breath, but it was too late. People were flipping through the documents. Carl leaned forward. You mean they've been writing fines without legal authority? Hal told me later that was the moment everything shifted. The committee agreed to escalate the case to mediation, but I didn't wait. I filed a petition in civil court against the HOA for attempted seizure of private property, citing municipal code violations and fraudulent representation to a government office. Elaina tried to dodge the court date, but the subpoena landed at her door 2 weeks later. In court, she wore a beige blazer like she was running for office. Her lawyer, a local guy clearly just trying to get through the day, opened with some nonsense about shared community interests. The judge, a silver-haired woman with reading glasses halfway down her nose, glanced at the preliminary filings, then looked over her glasses. Is this a joke? Elena's lawyer stammered. We believe the HOA acted within its rights to redefine a resident's private dock as community property without a vote, without notice, and while submitting altered zoning requests to the county. The judge cut in. I see no legal precedent, statute, or even a whisper of due process here. Elaina shifted in her seat. I handed over the trail cam footage, the emails, the ordinances, and the zoning request. The judge watched the clip of Todd inspecting the boathouse, paused it, and turned to him. Were you authorized to enter his property? Todd didn't answer. Let the record show no answer was given. By the end of the hearing, the judge issued a cease and desist order against the HOA, nullified every fine issued under the bogus ordinance, and ordered a formal review of the board's practices by the city's compliance office. Outside the courthouse, I didn't say a word, but word traveled fast. A week later, Elaina stepped down for personal reasons. Todd tried to run for president. He lost, spectacularly. Carl was elected by a landslide, and his first act as HOA president was to pass a motion banning any future property reclassification attempts without a notarized vote and a 2/3 majority. I took down the trail cam. Didn't need it anymore. The dock is still standing, and now no one dares set foot on it without asking first. Funny how quiet things got once the neighborhood learned what happens when you mess with a man's dock. And he knows the law better than you. 3 weeks after the court ruling, you'd think peace would have settled over the neighborhood like a good summer rain. But people like Elaina don't go quietly. Her resignation didn't come with an apology or explanation, just a typed letter posted to the community board, claiming she needed to focus on her health and family. No one bought it, especially not after what came next. The city's compliance office followed through on the judge's order and launched an official audit of the HOA's finances and internal practices. I hadn't thought much of it at first. The whole thing felt symbolic, maybe a slap on the wrist. But then the city investigator, a wiry man in his 50s named Samuel Griggs, knocked on my door with a leather-bound notebook and a badge clipped to his coat pocket. "I'm reviewing financial records and board communications," he said. "You mentioned in your complaint that the HOA submitted zoning documents under false pretenses. I need to know if that was isolated." I stepped aside and let him in. Over coffee, Samuel asked about the HOA's budget meetings, member elections, and any unusual charges on our dues over the past 2 years. I mentioned how the landscaping fees had ballooned out of nowhere last spring and how the Community Improvement Fund turned into a catch-all excuse for whatever Elaina wanted to push through. Samuel nodded and jotted notes. "You ever see a breakdown of those expenses?" he asked. "No," I said. Every time someone asked, she said the records were available by request only and then never responded. That got his attention. He closed the notebook with a deliberate snap and stood. "Appreciate your time, Mr. Langley. If you think of anything else, give me a call." 2 days later, half the board's email accounts were subpoenaed. The real storm rolled in after that. Turns out, the Community Improvement Fund had been used to pay for a number of questionable purchases. Thousands on catering for board only, planning retreats, luxury furniture delivered to Elaina's private residence under the HOA's shipping account, and payments to a consulting firm that didn't appear to actually exist. It didn't take a genius to figure out what was going on. The HOA wasn't just overreaching, they were laundering money through fake vendors and billing residents for it. Elaina was arrested on a Thursday morning, still in her robe, according to one neighbor who lived across the street. She was charged with embezzlement, falsifying municipal records, and abuse of fiduciary duty. Todd wasn't far behind. He'd been signing off on every check. The rest of the board tried to distance themselves, but the damage was done. The city froze the HOA's accounts pending further investigation, and a temporary oversight committee stepped in to manage essential services. I didn't celebrate, not publicly. But I did sit out on my dock that evening, legs dangling over the edge, watching the water turn gold with the setting sun. It was quiet, not a single speaker blaring on the lake, no fishing poles where they didn't belong. The next morning, I got a call from Samuel. "There's something you should see," he said. "Meet me at the city records office." Down in the archives, he pulled out a box labeled Lakeside HOA Charter Amendments. Inside were copies of every bylaw change submitted over the last 10 years. Most were routine, but one dated 3 years ago stood out. It was an amendment granting the board unilateral power to adjust property boundaries for the purpose of optimizing community access. I frowned. That doesn't sound legal. It's not, Samuel said, and it was never recorded properly. But someone tried to use it to justify the easement request on your dock. He handed me a printed email with Elaina's name at the top. In it, she instructed the HOA's legal counsel to expedite the claim on Langley's shoreline. He's isolated and unlikely to push back. I wasn't angry. Not anymore. Just deeply satisfied that her arrogance had been written down in black and white. The city filed additional charges based on forged amendment filings. Her trial date was set for late summer, and the prosecution was building a case that could land her in prison for years. Meanwhile, the community was changing. At the next meeting open to all residents, Carl stood at the front of the room with an old wooden gavel and a list of proposals. Every seat was filled. Even some of the quiet folks who usually kept to themselves showed up. "We're not here to relive the past," he began, "but we sure as hell won't repeat it." Applause broke out. I sat in the back, arms crossed, just listening. Carl proposed a full rewrite of the HOA charter with input from every homeowner, and a system of rotating board members so no one could hold power indefinitely. He also introduced a transparency policy. All financial records would be posted online monthly, and any homeowner could request a review with 48 hours notice. The vote passed unanimously. After the meeting, Carl approached me by the coffee table. "You good with all this?" he asked. I nodded. "Better than I expected." "Good," he said. "Because I want to name the new dock policy after you, Langley Clause. No property can be reclassified without notarized consent from the deed holder." I laughed. "I don't need my name on anything, Carl." Just glad people finally woke up. But he was already writing it down. Later that week, I got a letter from the city council. They'd reviewed the HOA's violations and were drafting new municipal standards for how HOAs could operate within city limits. My case had triggered the overhaul. The letter ended with a short line: "Your persistence set a precedent." I kept it pinned to the corkboard in my garage, right under the photo of Brandon and me with that first dock plank. One evening, as I was putting away the garden hose, Brandon pulled into the driveway, home from college for the weekend. He looked out at the lake and grinned. "Dock still standing, you bet." He walked down to the edge and sat, just like we used to. I joined him, and for a long while we didn't say anything. Eventually he said, "Heard about the trial. Think she'll get time?" "Probably," I said. "But that's not what matters." He looked over, waiting. "What matters is, next time someone like her tries to push people around, they'll think twice," I said. "Because now they know someone's watching." Then the wind shifted and the lake rippled and the sun dipped lower. Peaceful but never passive, just the way it should be. The morning, the forensic audit results were released. I was already on my second cup of coffee, flipping through the classifieds for a used outboard motor. The old one had finally given up, and I figured it was time to replace it now that the lake was back to belonging to the people who actually lived beside it. I wasn't expecting a knock at the door before 8. But when I opened it, there stood Samuel Griggs again, this time holding a thick manila folder and wearing an expression that wasn't quite satisfaction, but something close. "You might want to sit down," he said, stepping inside without waiting. I led him to the kitchen and gestured to the table. He set the folder down, flipped it open, and slid a stapled packet across to me. "We finished the audit. It's worse than we thought." I scanned the first page. Page after page of itemized expenses, bank transfer logs, and vendor invoices. But something jumped out immediately. "What's this Lakeside Preservation Consulting billing $6,000 a month for community analysis?" I asked. Samuel nodded. "Fake company. Registered to a P.O. box in Raleigh. Payments were routed through 4 different accounts, all of which ultimately tie back to Elaina's second cousin. He's already confessed to setting it up under her instruction." I kept reading. $4,000 for shoreline restoration planning." I looked up. Nothing was restored. They barely trimmed the reeds. Exactly, that invoice was fabricated entirely, and the signature of the approval forged. Belongs to a former board member who moved out 2 years ago. She had no idea her name was still being used. I leaned back in my chair. So they weren't just overstepping. This was fraud through and through. Samuel pulled out another sheet. This one had a list of charges, each with a handwritten note beside it, comments from the DA's office. They were building a case not just for embezzlement, but for organized financial crime. She's being indicted under the Racketeer Influenced and Corrupt Organizations Act, he said. RICO. It's rare for HOA cases, but this qualifies. Multiple actors, coordinated fraud, forged documents, and attempts to manipulate local zoning for personal gain. I stared at the paper, then at him. You're saying she could go to federal prison, he nodded. Not could, will. The evidence is overwhelming. That same afternoon, 2 unmarked vehicles pulled up to the former HOA office. 3 agents in plain clothes walked out with hard drives, boxes of files, and 2 laptops wrapped in evidence bags. I watched from my porch as Todd, now unemployed and looking like he hadn't shaved in days, stood on the curb trying to talk to one of the agents. They didn't even glance at him. Later that week, I got a subpoena not as a defendant, but as a witness. The prosecution wanted me to testify about the fabricated easement attempt on my dock, especially in light of the forged amendment they'd uncovered. Apparently, that was a key piece. Elaina had used it as a legal footbridge to justify her other land grabs, including an attempt to claim a portion of the greenbelt behind another resident's home for a future community storage shed. That resident, a kindergarten teacher named Naomi, had only found out because her sprinkler system was mysteriously torn up and flagged for non-compliance. The trial began in midsummer. The courthouse was packed. Local news vans lined the street. A few HOA board members who had quietly resigned after the audit were now called to testify. Most claimed ignorance. Some broke down on the stand. One admitted he'd signed blank checks at Elaina's insistence, just to keep things moving. When I was called up, the courtroom was silent. I told them about the notice on my boathouse, the teenagers on my dock, the zoning documents with Dana Strickland, the fake fines, the trail camera footage, and the meeting where Elaina had tried to bluff her way through a sham ordinance. The prosecutor handed me an enlarged photo of the forged amendment. Is this the document she cited as justification? Yes, I said. It was never voted on. No one even knew it existed. And was there any notification to homeowners about this change? None. The defense attorney tried to trip me up, suggesting that perhaps I had misunderstood the nature of community shoreline rights. I looked him square in the eye. I built that dock myself. Paid for the permit. Filed every inspection report. The only misunderstanding here is thinking someone like her could take it without a fight. The judge sustained the prosecution's final objection and dismissed the defense's argument. By the end of the week, the jury didn't deliberate long. Elaina was found guilty on all counts: wire fraud, criminal conspiracy, falsifying legal documents, and misuse of public office. Todd was convicted on a lesser charge for knowingly signing off on fraudulent expenses, but was spared jail in exchange for full cooperation. Elaina didn't even look at anyone when the sentence was read. 5 years in federal prison, no parole for at least 3. She was led out in cuffs, her designer heels echoing one last time down the courthouse corridor. The community didn't celebrate, at least, not in the usual sense. But there was a quiet pride that spread across Lakeside. Carl's reforms went into full effect. The HOA was stripped of discretionary spending power. All future board positions required disclosure of any financial ties to vendors. Naomi was elected as the new treasurer, and she implemented a monthly community review night where all homeowners could review receipts and project plans in person. I went back to my dock the night after the verdict. Brandon was due home again soon, and I'd finally found an old outboard that just needed a little tuning. As I checked the bolts on the motor mount, Carl came walking down the hill with a beer in each hand. "Figured we'd earned these," he said, handing one over. I took it and popped the cap. "Never thought I'd see the day an HOA president brought me a beer," he laughed. "Never thought I'd be one, but here we are." We sat in silence for a while, listening to the frogs and the creak of water against the pilings. "Funny how it all started with a notice on a boathouse," he said. "Yeah," I replied, "and ended with a federal indictment." He raised his bottle. "To the Langley clause," I clinked mine against his, "to keeping what's ours." That night the lake was calm, no unauthorized visitors, no blaring music. Just the glow of porch lights reflecting on the water and the steady hum of crickets in the distance. And for the first time in a long while, there was nothing left to fight.